Martinez vs. Ryan and the effects of Shinn vs. Ramirez. You must cite record-based claims. Is this the hidden key? Is there still an ability to cite ineffective assistance of post-conviction relief counsel as the cause for procedural default, despite the court's decision in Shinn vs. Ryan? The Martinez vs. Ryan court held that a claim of ineffective assistance of post-conviction relief counsel could serve as cause for a procedural default of a claim of ineffective assistance of trial counsel. To establish that PCR counsel provided ineffective assistance of counsel, the petitioner must show that PCR counsel was deficient and that that deficiency actually prejudiced the petitioner. This must be shown by applying the Strickland v. Washington deficiency and prejudice prongs to PCR counsel. The underlying ineffective assistance of trial or plea counsel must be a substantial claim, meaning the claim must have merit. However, the U.S. Supreme Court subsequently ruled in the case of Shinn v. Ramirez that the federal habeas court may not consider evidence beyond the existing state court record when evaluating an ineffective assistance of PCR counsel claim. The U.S. court's ruling in Shinn v. Ramirez has been both jaw-dropping and frustrating to many federal habeas petitioners and their federal habeas lawyers, as both have struggled with how they can possibly show both ineffective assistance of PCR counsel, applying the Strickland standard to this counsel, and ineffective assistance of trial or plea counsel, applying the Strickland standard to this counsel, at the same time, without adding to or asking the court to look beyond or outside of the existing state court record for this evidence and proof, which would show the ineffectiveness of these counsels. The answer or key is that the ineffectiveness must be record-based. This means the petitioner must have a well-established record which demonstrates both trial or plea counsel's behavior. This means that the actual ineffectiveness of trial or plea counsel must be clearly visible to someone simply by them examining the transcript of the trial/plea court. If a person could see simply by viewing the transcript of the trial or plea proceeding that trial or plea counsel made significant errors which prejudiced the case, then Shinn v. Ramirez is no barrier. In explaining cause, one could then argue that PCR counsel should have read the trial or plea transcript and ensured that all significant issues of ineffective assistance of trial or plea counsel were raised in the PCR proceeding. A claim is record-based when a reviewing court could conclude that defendant's counsel was ineffective simply by reviewing the trial record without the benefit of additional background facts that would need to be developed through a post-conviction relief hearing. See the case of Sims v. Artis, No. 14 CV 4734, 2016, WL 646-2405. A case in the Southern District of New York, July 7, 2016.